Hello, my name is Aina Delima binti Basrihuddin, and I will present about confidentiality in professionalism and ethics in psychology. First, we will go through the important terms for this topic. What is confidentiality? It refers to a duty of an individual to refrain from sharing confidential information with others. For example, maintaining and protecting clients' privacy by not revealing the contents of the therapy to an unauthorized person. It is a counselor's ethical duty to protect private client communication, however, there are exceptions. Next is privacy. The definition of privacy is the basic right of individuals to be free from any intrusions. For information privacy, it is having the rights over how your personal information is collected and used. Privileged communication. Privileged communication is an interaction between two parties in which the law recognizes as a private protected relationship. Whatever that is communicated between the two parties, which is you, the therapist, and your client, must remain confidential, and the law cannot force their disclosure. Basically, a counselor or therapist have the right to refuse from answering any questions in the court or produce any records. However, the specifics of these dates may vary. Confidentiality between counselor and client before session. At the beginning of counseling, clients are informed about the privacy policy of their counselor or therapist, usually through consent-informed forms. Most informed consent starts off with the explanation of the counselor's commitment to confidentiality and when it will be broken, such as if a person declares suicidal intent or violence towards others. The therapist may ask for clients' permission to share some information with the insurer if they use insurance, but typically not much is revealed except for the diagnosis and if there are any medications required. Confidentiality for underage clients. Younger people are not considered as mature enough to consent to counseling session, so their parents are expected to consent on their behalf. Thus, these minors, they don't have strong confidentiality rights that most adults have. To ensure the trust with minors in therapy, many counselors seek the approval of the client's parents to keep the therapy confidential. Even when the parents disagree about confidentiality, therapists will not necessarily reveal the details about their discussions in therapy, but they will give the feedbacks on treatment goals and progress. However, counselors or therapists may break confidentiality and disclose to parents if they deem the matter as appropriate, for example, self-harm, pregnancy, or abuse. So before you go into any therapy session, make sure you ask your therapist or counselor about your privacy policy standard. If you encounter your therapist in public, don't worry about them approaching you. Because of confidentiality purposes, they would not acknowledge you unless you do first. Why is it so important to take care of confidentiality? Patients constantly share their personal information with their counselor or therapist. If the confidentiality for this information was not protected, trust in client-counselor relationship would be hard to maintain. Creating a trusting environment by respecting clients' privacy encourages the client to speak out and may also increase the client's willingness to join therapy. However, there are limits to confidentiality. Knowing when to break confidentiality in counseling is key because there are situations in which the therapist will be obligated to do so. Here are some examples. First, concrete signs of suicidal intent. Second, possible planned violence towards others. Third, experiencing abuse. Fourth, when a client discloses intention to commit a crime. And fifth, when it involves the law. What would happen if the therapist breached the privacy of a client? First, it could create a loss of trust, which can ruin the relationship that has been established with the client, and it could jeopardize the progress you have made with them. Second, you are at risk for a loss of job. If the therapist is employed with an agency and they breach confidentiality, they may be fired as a result of your failure to follow the company procedure. Third is legal issues. By breaching confidentiality with a client, you expose yourself to several different legal issues. The client may sue you for financial or emotional damage as a result of you exposing their private information. Breach of confidentiality social networks. The popularity of social networks has grown rapidly in recent years. Widespread usage of social medias like Twitter and Facebook may cause potential risks of confidentiality breach to rise. Here are some of the information that may be exposed due to social media. Client's diagnosis, the client's treatment, the identity of the client itself, the client's character and attitude, and also events that are affecting the client. The implications of this breach is the breach of legal duty of confidentiality. The duty of confidentiality is not only an ethical duty, but also a legal duty as well. Therefore, by discussing information pertaining to the patients on social networks can amount to a breach of legal duty of confidentiality. Second is violating the client's right of privacy. A Twitter user called Kaylee Holmes has seen her share of mental health professionals violating patients' confidentiality online. One therapist that she followed on Twitter, for example, posted a client quote of the day, and another therapist shared their location where she was doing exposure therapy with a driving phobic client. Privacy issue with telecommunication device. The use of telephone, answering machines, and emails can pose a lot of ethical problems. How? First, your calls with your client could be intercepted or overheard by an unauthorized person. Second, when you leave a message to the answering machine, a different person might receive it instead. Third, if your client is a minor, their parents might go through their phones and text messages, and they might see things that they're not supposed to see. How do we deal with these telecommunication device privacy issues? First, you have to make sure that your clients aren't giving out information or receiving services from unknown callers. They should verify first who's on the other hand on the phone. Second, when you are making a call with confidential information, make sure you verify the person on the other end of the call, because you might accidentally call the wrong person, or another person might have answered the phone on behalf of your client. So you have to make sure that you are actually talking to your client. Third, you have to be aware that your conversation on the phone may be recorded or monitored by a third person. Fourth, you have to avoid saying anything that you would not want to repeat in legal proceedings. Fifth, do not allow any unauthorized person to hear or receive your messages. You might have a secretary that can open your answering machine, so you have to make sure that they understand that you're the only one that could receive the messages. 6. When you leave a message, be aware that an unintended person might be receiving it instead of your client. And that is all from me. Thank you.
Hello and good morning. My name is Noor Akma, and I will be presenting on the duty to warn and the duty to protect and the subcomponents that falls under it. So to start, the duty to warn and the duty to protect actually begins with the acknowledgement on the differences on the ethical responsibility of confidentiality, and the legal term of privileged communication. So, the duty to warn is an obligation of a counselor or any social worker to tell third parties or authorities if their client presents a threat to themselves or to another person. While the duty to protect is the duty of the counselor to break confidentiality if they think their client presents a serious danger to another in order to protect the intended victim against danger. The legal precedent that established the duty to warn and the duty to protect was actually set in the wrongful death case of Tarasov versus the Regents of the University of California. Podar Pranjit is an exchange student from India enrolled at the University of California. So he met Tatiana Tarasov in at a party and was quick to fall heads over heels for her. So in that party, they actually shared maybe like a romantic evening together and they shared a kiss. But his confession to Miss Tarasov was actually rejected, and she confesses that she wasn't actually being serious with Pranjit. And because of this, Podar became distraught and depressed. Even with Miss Tarasov's rejection, Podar still continued seeing her, and he will always film a video when they are together and would rewatch to figure out why Tarasov is not into him. So when Tarasov went to a vacation in Brazil, uh, Podar thought to himself and think that he should sort out counseling at the University Counseling Center. And he actually got better because of his therapy. However, when Miss Tarasov came back to the university, Podar actually went back to his depression state. And during his therapy section, his fantasy of harming Miss Tarasov had become clear to the psychologist that was working with him. And concerned about what's going to happen, the psychologist actually brought this issue to his colleague, and they figured out that they should actually notify the police campus about Podar's intention. When the police arrested and questioned Podar about his intention, he assured them that he would not harm Ms. Tarasov and he was let free. The head of the counseling center was actually mad and furious and also embarrassed that on a on the incident that happened between Podar and his psychologist. So, as a punishment, he fired Podar's psychologist, and Podar's therapy was later terminated. And eventually, without his therapy session, Podar became severely depressed and actually went to Miss Tarasov's house to shot her with a pellet gun. So, as she ran away, Podar chased her with a kitchen knife and ultimately killed her. So, Miss Tarasov's parents filed the wrongful death suits against the university as well as the psychologist and the psychiatrist because of their negligence to warn Miss Tarasov of the imminent danger possessed by Podar. And the defendant won in the lower court case, but the case was appealed and the original ruling was overturned. Moving on to the California Supreme Court ruling. So, when we are talking about the Tarasov case, we're actually talking about two cases here. There was the Tarasov ruling in 1974 that provided us with the duty to warn. And then the Tarasov case 1 was actually vacated by the Tarasov case 2 that takes place in the 1976, and this changed the duty to warn over to a duty to protect. Therefore, in conclusion, this increases the for the therapist, as now it was the duty to protect and not necessarily the duty to warn. So from here we learn that in the Tarasov case 2, The key finding was that the protective privilege in therapy ends when peril begins. Next is the guidelines of the duty to protect potential victims. So there's actually no simple formula that determines when the duty to protect and the duty to warn will rise, as each case differ and vary among states. But generally, a counselor should first approach potentially dangerous client with sensitivity, attend to detail and standard of care in therapeutic interventions, and apply a procedure for assessing dangerousness and record keeping. In addition to this, past record could also be revised in order to evaluate a client's history and tendency for violence, and for any information that would give rise to believe that a client will injure a third party. So this intended guideline is to show a counselor on how to treat a potentially dangerous client while observing their legal obligation. So first, inform clients at the outset of and during the relationship of confidentiality limitations, and include these limitations in an informed consent document that is signed by both the counselor and the client. So this is just to make sure that the client understand if the counselor needs to breach their confidentiality. Next is to formulate and enact steps to assess dangerousness, such as determining if the potential danger is imminent and whether a threat is to an identifiable or foreseeable victim. At a minimum, a dangerous assessment should include the client's history of violence, evaluation of current thoughts, and aggressive behavior. The third one is, if the counselor determines imminent dangerousness, the next step is to notify the intended victim and require professionals such as the police or authorities. If possible, the counselor should also consult other qualified mental health practitioners as to what they should do to prevent victimization. The fourth step is to apply therapeutically related steps with clients, such as maybe the counselor could increase their counseling sessions, refer their client for a medical evaluation, or teaching anger management skills. Next is to document the justification of the decision to disclose confidential client information, consultations with any necessary professionals such as psychiatrists, attorneys, law enforcement officials, and any action taken. And the last step is to check recommendations to be certain they were followed. Moving on to the liability for civil damages. The meaning of civil liability is when a counselor commits wrong to their client that may be unprofessional but not necessarily illegal. For example, failing to misdiagnose a client, or failing to follow over the duty to warn and the duty to protect, and failure to act on these responsibilities to protect the public from violent clients may entail legal actions to come into play. Like a counselor could lose their license, face criminal offense, and pay some sorts of penalty. The next slide is guidelines to assess suicidal behavior. First, a counselor must take direct verbal warnings seriously and pay attention to previous suicide attempts. Next is identify clients suffering from depression, be alert for feelings of hopelessness and helplessness, monitor severe anxiety and panic attacks, explore the interpersonal stressor of loss and separation, be certain to whether if there has been a recent diagnosis of a serious or terminal health condition, ascertain whether there has been any suicide in the family, assess the client's support system. It is shown that if a suicidal person does not have a good support system, they are more likely to fall into a deeper depression. Determine whether the client has a plan. So, determine whether they have a plan to recover or go to any therapy. Identify clients who have a history of severe alcohol and drug abuse. Be alert to client behaviors. Determine the history of psychiatric treatment. So, Dinerstein versus the United States is a case example that shows how a psychiatrist failed to follow with the duty to protect their client that has a suicidal tendency. For as long as 6 years before his death on January 4, 1969, Howard Dinerstein had suffered recurrent episodes of depression serious enough that it requires him to be in a psychiatric care. So on the January 31st, 1968, he went into an accident. Though little damage was done to the car and to himself, Dinerstein admitted to his wife that the accident was actually a suicide attempt. So the same day, he was admitted again voluntarily to the psychiatric hospital. He remained there under observation until February 12th. Although Dinerstein was considered a suicide risk, he was still granted the freedom of movement. Soon, Dinerstein went back into his depression state, and he was admitted with a new private psychiatrist that convinced him to admit himself into another hospital. However, Dinerstein's condition took a turn for the worse. He would not leave his bed nor do anything for himself. By November 14, he actually had improved, and he was again discharged. However, the cycle again turned downward as he was treated again by his private psychiatrist, and again he was recommended hospitalization. Although his psychiatrist was aware of his history of recurrent depression, he still would not put any restriction or special supervision for Dinerstein when he was hospitalized, and the psychiatrist also discontinued the antidepressant that Dinerstein was on. So Dinerstein complained to his psychiatrist that he was actually more depressed since arriving to the hospital, but the psychiatrist just waved it off. And on the following day, on January 4th, Dinerstein actually killed himself by jumping over from his ward. From this case, we learned that the hospital should have known of the real possibility of a suicide attempt, that it failed to take appropriate measure to guard Dinerstein against that danger, and that it was its duty to do so, and that having failed to act with that duty, the United States is liable to the death of Dinerstein. Next is the duty to protect against abuse of children, elderly, and dependent adults. Counselors are encouraged to report any cases that might be involved in abuse of children, elderly, and dependent adults. So, abuse is not necessarily in terms of physical, it could be sexual abuse, emotional abuse, neglect, abandonment, and financial abuse. So, if a client discloses that they are experiencing abuse or neglect, it is the counselor's obligation to report these situations to authorities. And it is also mandatory for any social worker to protect those who cannot advocate for themselves. Moving on to the duty to protect and domestic violence. When working with clients who have a history of domestic violence, it is important to do a risk assessment of the situation to determine if there is a potential for harm. Counselors also need to protect potential victims by referring them to a safe place where they are not exposed to violence. And depending on the state, social workers have a legal obligation to report threats of violence and to warn the potential victims. And there are different levels of obligation to report specific threats of violence or intention to act. Lastly, is the duty to warn and protect with an HIV. So, as we all know, social workers often work with clients who have HIV or AIDS. And it is actually very important to maintain confidentiality with these clients as they are often stigmatized. However, the question of whether a counselor should warn a third party if their partner is at risk of transmitting is still left unanswered, especially if the client refuses to warn their sexual partners. In 1995, Stanner and Hasler found the obligation of the duty to warn for HIV as important as the case example provided here. Brian is a 24-year-old married bisexual man entering counseling to deal with grief and depression associated with a recent diagnosis of his HIV infection. So during the course of counseling, Brian discloses that he continues to be sexually active with his wife and also occasionally with anonymous male partners. Brian does not disclose his diagnosis to anyone and maintains that it is not necessarily to do so because he practices safe sex. So, because of this, his counselor actually has the obligation to tell his sexual partner about his HIV infection. Therapists should also proceed with cautious guidelines if their client discloses their intent to harm individual without consent and protection. But keeping in mind, a counselor should follow the requirement of their state's law when reporting. And that is all for me. Thank you.